Okay, good afternoon, and welcome everyone to Eckstein Hall and our Lubar Center. My name is Joseph Kearney, and it is a great privilege for me as Dean of the Law School to introduce our Nies Lecture in Intellectual Property. At this most busy time of the academic year, we are so grateful and delighted that all of you are here today for this more or less annual tradition. Give us one more year and we will begin just calling it annual again without an implicit nod to any pandemic hiatus. I would like to begin by remembering briefly the person in whose memory this lecture stands. The law school created this lecture series in 1998 to honor the late Helen Wilson Nies, who had served as a judge of the United States Court of Appeals for the Federal Circuit. Even now, more than a generation after her judicial service and lifetime, Judge Nies continues to be remembered within the intellectual property community as a very generous individual and a hardworking, accomplished, and modest judge. The idea for the lecture came from a member of our faculty at the time in the late 1990s. We are no less fortunate today with Professors Bruce Boyden and Kaylee Murray serving as professors of law and co-directors of our intellectual property program. They lead us not only generally in this realm with a relentless and impressive focus on our students, but also in helping ensure that we host annually a distinguished leader in IP as our Nies lecturer. This year's Nies lecturer is Margot Bagley, who is the Associate Dean for Research and the Asa Griggs Candler Professor of Law at Emory University. Professor Bagley has had a number of other academic appointments, including service for a decade as a professor at the University of Virginia School of Law, and this past fall as the Heiken Visiting Professor in Patent Law at Harvard Law School. She also has experience as a practitioner and has had extensive engagement with government and non-government organizations in the United States and internationally. She has a particular affinity for Emory and Georgia, I expect, being not only a faculty member there, but also with its being the law school from which she graduated, Emory, that is. So in a sense, she went home to teach. We can not yet claim her for Marquette University, it is true, but you may have noticed in registering for the lecture that Professor Bagley received her undergraduate degree, a Bachelor of Science in Chemical Engineering from the University of Wisconsin-Madison. Perhaps that explains her wise request to do the lecture as late in April as we were willing, so that the weather might have the best chance of being good. I think the jury is still out with respect to that today. So to all of you, I would say please join me in welcoming back home to Wisconsin and for the first time to Marquette University Law School, Professor Margot Bagley. Her Nies lecture today will take up the topic of innovator ecosystem diversity as a global competitiveness imperative. Please welcome Professor Bagley.
Good afternoon. I am so delighted to be here with you today and honored to have been invited by Dean Kearney on the recommendation of Professors Boyden and Murray, both outstanding IP scholars, to deliver the Nies lecture, named in honor of an incredible Federal Circuit jurist. In fact, it was 1996 when I graduated from law school and was about to begin my career as a patent attorney that Judge Nies unfortunately, tragically died. I have been so impressed with Dean Kearney's meticulous preparations for this event, his well-deserved pride in your beautiful facility, and the quality of your faculty, staff, students, and alumni, and his generous commitment of time to preparing for this event. He's been the consummate host from the moment he sent the invitation, and I am delighted to be able to bring to fruition what we discussed so many months ago. As mentioned, the title of my talk, and this is the only one that has the fun animation, sorry, but I just thought those were so cute, is Innovator Ecosystem Diversity as a Global Competitiveness Imperative. And my remarks today involve an aspect of a project that I'm working on that really is probably the next logical step in my scholarly trajectory, but one that I did not see coming. Oh, wait, I have to pause. There's a special guest in the audience, and that's my mom. I'm so glad to have her here. My mom, Marjorie Cooper, she has been so wonderfully supportive all of my life, and I thank God for her. So, in the work that I do as a professor who focuses on international and comparative patent law, I have, over time, and really surprisingly to me, developed a strong justice component in my work, influenced both by my faith principles and my experiences as an African-American female in the United States. So whether on topics related to patents and access to medicines, patents on new biotech inventions, controversial biotech inventions, or patents and access and benefit sharing obligations in relation to indigenous peoples and local communities, I feel like I often find myself in the position of supporting the disadvantaged and seeking justice and fairness for those who may not be able to articulate compelling narratives for themselves in various fora. So to begin, I just want to remind us of some features of patents. I know it's an IP lecture, most everybody knows, but just in case there's some folks who don't tend to focus on patents, just some of the features of patents that are relevant to my remarks. So patents, most simply, are rights that are granted by the government, allowing an inventor to exclude others from making, using, selling, offering to sell, or importing into the United States the invention for a particular term, which these days runs for around 20 years from the filing date of the patent. And patents have attributes of personal property. You can buy them and sell them, bequeath them, license them, do all kinds of wonderful things with them, just like other kinds of property. But patent rights are territorial. Therefore, there is no such thing as a global patent. And if you want protection in other countries, then you need to file applications and seek protection in each of the countries or regions where you want to have protection. In the United States, the authority for Congress to create a patent system lies in the Constitution, Article 8, Section 8, Clause 8, which authorizes, but does not mandate, the creation of exclusive rights for limited times to authors and inventors for their respective writings and discoveries. And in the words of the only US president to obtain a patent on an invention, Abraham Lincoln, patents added the fuel of interest to the fire of genius. Now, the US government has had a fairly pro-patentee stance, certainly in international negotiations, even if not always at home, that is well reflected by this quote that I often use in my international patent law class. It's from a seminal article by Cronstein and Till, and they point out that the Americans' view, and this was at a time they're talking about during the negotiations in relation to the Paris Convention, which was the first big multilateral industrial property treaty in 1886, and that there was this view that Americans had that was different to the view of many other countries, this actual faith that patents under the control of private owners would not be subject to abuse. And the files of the US Patent Office contain a constant reiteration of this theme, a belief in the beneficent effects of an uncontrolled patent system. It was precisely this freedom, it was believed, which accounted for the rapid technological advance in the United States. So leading the world in patent filings was really a normal, expected thing. And you can see the top line is US patents, followed by Japan. for a long time. And then in the 70s, we see Japan taking the lead for a while. But it was widely understood at the time that in many cases, the Japanese were patenting really incremental inventions and creating patent portfolios around strong US rights, as opposed to coming up with very many new inventions. They would do lots of trying to block and kind of fence US IP in, or US inventors in. But since at least the 1970s, as the American tech industry started to take off, the US has been pushing other countries to adopt stronger IP protections, particularly for patents and copyrights. In strategic plan after strategic plan, we see a focus on expanding international leadership in IP and focusing on countries to ensure that they are providing adequate protection for our domestic industries. But why? Why do we care what other countries do in relation to IP? Well, this concern is articulated by Professor J. Thomas McCarthy some years ago. He said that Americans should care if other countries do not protect IP over technical and entertainment information, because without it, we have very little to sell to the rest of the world. And he pointed to the replacement of US Steel by the Walt Disney Company on the Dow Jones Index as a sign of the growing importance of intellectual property to the US economy. According to the US Chamber of Commerce, America's IP is worth $6.6 trillion, more than the nominal GDP of any country in the world. IP-intensive industries account for over a third of total US GDP. The direct and indirect economic impacts of innovation are overwhelming, accounting for more than 40% of US economic growth and employment. Now, this is the US Chamber of Commerce. These numbers may be somewhat exaggerated, but nevertheless, they do suggest that IP is important to the United States. Now, I've always liked this infographic and found it helpful in terms of showing the shift in the weight of GDP and American corporate wealth from tangible to intangible. So you see the green line being the US population increasing, but the dark blue line being the weight of GDP really decreasing and then kind of holding steady. But the dollar value of GDP in red going up, up, up. And that shows the intangible, the switch or the move from tangible to intangible dollar value in our GDP. Again, an indication that intellectual property is important. Professor McCarthy also suggested that we needed to focus on what we are good at in America: information products and entertainment. And he noted the movement abroad of so much manufacturing to China. And that's why we should focus on what we're good at. However, he and seemingly others may not have fully considered the ramifications of copiers eventually moving from imitation to innovation, urged on by US corporate interests. Now, the US and China, our relationship is complex. We cooperate. Here we've got the heads of the 5 largest IP offices. So it's the United States, the Chinese National Intellectual Property Administration, the Japanese Patent Office, the Korean Patent Office, and the European Patent Office. So we do cooperate. But at the same time, we also don't always get along. And China has long been a concern for the United States due to rampant copying and counterfeiting activity in the country, lax IP laws, and low damages awards for infringement. Of course, as the 2 largest economies on the globe, with each striving for dominance, the relationship is complex, and the political, military, and economic complexities cannot be disentangled from the IP complexities. Some specific US concerns that I have here, wanting China to create a copyright law and protect software. Again, concerns about rampant counterfeiting activity. The US brought in action in the World Trade Organization in 2007 against certain Chinese IP policies again, relating to, in large part, counterfeiting. Concerns about China's indigenous innovation policy, where they were innovating through co-opting and copying technology developed elsewhere, in some cases forcing companies, if they wanted to do business in China, to share their intellectual property, their technology with them. The Made in China program, having a goal to have China dominate technology markets by 2049. And then we have even a commission on the theft of American intellectual property, which in its 2013 report said that China was the world's largest source of IP theft. And the 2019 report called China the most active and persistent perpetrator of economic espionage. Now, some say that that's a bit hypocritical on the part of the United States, because we kind of did the same thing back when we were developing industrially. We didn't pay all that much attention to IP rights, in particular copyright rights, until it made sense for us to do so. But nevertheless, it is a concern. And in a report by the United States International Trade Commission on the effects of infringement by China and Chinese entities, it said it cost the US economy approximately $48 billion in 2009 alone. $26 billion coming from the information and service sectors, more than $18 billion from the high-tech and heavy manufacturing sectors, in addition to billions from other sectors. If China complied with their current international obligations to protect and enforce intellectual property rights, 2.1 million jobs could be created in the United States. And the most direct job impacts would come in high-tech, innovative industries. I don't think it's very surprising that China is not terribly interested in creating jobs in the United States. But still, we have to be careful what we wish for. And what China is interested in is creating jobs and dominance in China. And with pressure from the US and others, China has come to see intellectual property as perhaps a vehicle for that economic growth. So a few years ago, several years ago now, I saw China's National Patent Development Strategy for 2011 to 2020, and I literally panicked. I'm like, oh my word, what on earth are we going to do? Because one of the goals was by 2015, China will rank in the top 2 countries in patents granted to domestic applicants and will file 2 million patent applications worldwide. So they wanted to become a country with a comparatively high level of creation, utilization, protection, and administration of patents, and set these goals. And the reason why I was so concerned was, at the time, there were not 2 million patents being filed everywhere, total, all the patents being filed. And for China alone to file 2 million patents, I'm like, oh my goodness, this is going to overwhelm the patent system. I don't know what's going to happen. Well, my worries were misplaced, and though China did reach its goal, our systems did not break, but that does not mean that there were no untoward consequences. So something interesting happens in this territorial scheme that we have set up for patents. And so I showed you the first part of this, where you see the US dominating and then switching with Japan. But something interesting happens in 1984. 1984 is when China adopted their first serious patent law. And you see this exponential growth in patenting. That's the red line that just goes up and up and up. That's China, eclipsing the US and everyone else in terms of the number of patent applications. This is applications received in the Chinese Patent Office. Well, it's not only about patenting in the Chinese Patent Office. They also were patenting in other patent offices as well. And when domestic patents are obtained by foreign entities, that tends to result in money flowing out of the domestic economy to the foreign country, because that's where those foreigners are located. So the monopoly privileges of patents have income flows. They have balance of payments implications because of income flows across national boundaries. And you see this wealth transfer. So if you look at, so upper middle income, just ignore, because that's China, and China just dwarfs everything else in terms of upper middle income countries. But when you look at lower middle income and low income countries, the dark green is non-resident, light green is resident. What you see is that in lower middle income and low income countries, most of the patents there are obtained by foreigners. So that's money that's going out of those countries. And oftentimes in poorer countries, not as many of the citizenry are involved in inventive activities, or they may be involved in inventive activities, but not able to obtain intellectual property protection for their innovations. High-income countries, we tend to see more of a balance. So in the United States, for the longest time, a little bit more than 50% of patent applications filed by US residents, US inventors. When we totally understood and were fine with some amount of foreign inventors, but never wanting to get to what the lower middle income and low income countries look like, and nor even seeing that as even something that could happen. But we started seeing something strange and unusual happening I guess, close to a decade ago, with fewer patents being issued to US residents than to non-residents. At the same time as we see China ramping up its patenting activity and filing patents at an unheard of rate. So not only did China's patent office overtake the US as the office receiving the most patent applications, but we also see in the United States, in the US patent office, fewer US inventors receiving patents as compared to foreigners receiving patents, which we could expect longer term to have some negative ramifications in the United States. Because if you own patents, you have the ability to enforce patents. And so that's lawsuits in the United States. That is higher prices on goods covered by patents in the United States, and the monopoly pricing going, again, to foreigners. So China now receives more than twice as many patent applications as the United States. When you look at the top offices, China is just way ahead. They took all of the criticism that they received from the US and others for so long and said, we'll fix y'all. We're going to just start patenting like crazy. And they have done that, not only, as I said, in filing in their own office, but filing in other offices as well. But with filing so many patents, you gotta wonder about the quality of those patents. And that is something that folks have been a bit concerned about, and they've been called, in some cases, junk patents. China on a mission to turn junk patents into treasure, getting everybody involved, all hands on deck, in filing patents in China. And there is some evidence that certainly early on, and when you're filing so many, there's going to be some proportion that are just not good quality. But there are also indications that quality is improving on the margins. So yes, now China has eclipsed the US in PCT filings. That stands for the Patent Cooperation Treaty, which is a treaty that basically just facilitates filing applications in other countries. And from the inception of the PCT in 1978, I believe it was, the United States had always dominated. We always were filing in other countries because we like those income flows coming back to the United States. So that is also another place where China is now dominating. And how is this happening? How are they doing this? Well, it seems to be tied to IP filing subsidies. And it's really fascinating. There are a number of different articles that focus on the ways that the Chinese government has been incentivizing citizens to patent, but using things like tax breaks, paying for patent application filing fees and examination fees, giving monetary awards for granted patents, housing benefits, and the one that is my personal favorite, reduced prison sentences. Yes, so wealthy prisoners can buy get-out-of-jail patents, and I am so serious, this is like a real thing. Prison terms can be commuted if convicts show they have come up with important technical innovations. But what they found was happening was cash-rich inmates were buying other inventors' ideas and patenting them in order to get a reduction in their term. And I love this. Agents even offer a bespoke service, scrutinizing the inmate's background in order to find the patent most likely to get time off their sentence. Some rich people come to us right after they get into trouble and before they go to jail. It takes a lot of early preparation to find the right. I'm like, really, really, yes. So this is really all hands on deck in China. So what about the US? What can we do? Well, we have a secret weapon, maybe not so secret, to counter China's move to dominate. And of course, it's not just about patent filings. It's about technological innovation. Don't really care if China has more patents. If indeed they were low-quality patents, well, I shouldn't say wouldn't really care, because since patents have a presumption of validity, it is expensive to try to invalidate them. So if you've got lots of patents, in fact, this is something that happens even in the United States quite often. I've heard stories, I won't name names, of companies that have large stacks of patents, and it's like, well, if they might threaten someone with an infringement, and the little company says, well, we don't think we infringe that. And they've got this other stack and say, well, you infringe one of these, so pay up. So yes, that is possibly a thing, but we have a secret weapon: women and underrepresented minority group members who can be drawn into the inventor ranks. The US is now attempting to activate and deploy that weapon in the battle for innovation supremacy. So racial and ethnic minorities, veterans, people who live in rural areas, all of these are targets now in this strategy because there has been a historical underrepresentation of women and minorities in all aspects of the innovation process. So inventors, scientists, patent agents and attorneys, PTO examiners, federal judges, everyone involved, every chain in the innovation process, we see a lack. So in the most recent draft USPTO, United States Patent and Trademark Office, strategic plan for 2022 to 2026, it hasn't even been fully adopted yet. It was posted for comments, and I guess final touches are being made. The goal number one is to drive inclusive US innovation and global competitiveness. And one significant way to drive global competitiveness is to ensure all Americans can participate fully in the innovation and entrepreneurial ecosystems that drive economic growth. We, along with every sector of the innovation community, must incentivize more Americans to enter, innovate in, and bring more innovation to impact in these fields. It's an interesting time in relation to this topic, and there are a number of factors that we can go into as to why it's happened, but the Success Act of 2018, among the many things that it included, was a requirement for the Patent Office to conduct a study using publicly available data, and the PTO is really at a disadvantage here because it doesn't collect demographic data. It does not know how many women or underrepresented minorities are patenting. Women patenting, those numbers that you might see in a study are based on names and an estimation of, well, this seems more like a female name. So it's not going to be completely accurate. But to prepare a study using publicly available data on the number of patents applied for by women, veterans, and minorities. And the study reported that innovation in the United States is highly concentrated. Vast swaths of our population are not fully participating. A different 2019 study of more than 1 million inventor patentees shows that among women, minorities, and individuals from low-income families, there are many lost Einsteins, high-ability individuals who would have contributed valuable inventions had they been exposed to invention and innovation as children. The findings indicate that increasing the rate of invention by women, minorities, and individuals from low-income households could quadruple the number of inventor patentees in America. But there are numerous barriers to inventing for women and underrepresented minorities, including some, well, at one time, even legal barriers. So, guessing lots of lawyers in here, you're familiar with the 1857 Dred Scott versus Stanford decision, where the Supreme Court said that blacks were not citizens of the United States. And that decision was the basis the following year for an attorney general decision that blacks also could not be inventors on patents, nor could the persons who enslaved them claim ownership of the enslaved person's invention via the patent system. The case involved the invention of an enslaved African-American man named Ned, who invented an improved double cotton scraper and two plows, a novel machine which could dramatically speed up the process of preparing fields for planting. And although the legal effect of that decision, it's called the invention of a slave decision, was short-lived, of course, its impact in facilitating a belief that African Americans could not invent was and remains profound. Kara Swanson, in her brilliant paper, Race and Selective Legal Memory, Reflections on Invention of a Slave, notes how black activists have, over many decades, sought to bring to light the inventions of black and brown people in the face of a persistent myth. And she cites Henry Baker, who was a black patent examiner and who collected evidence of patents granted to African Americans. And she wrote, in 1913, Baker noted that although his list of nearly 400 African-American patentees at that time sat in a book on the shelves of the Library of Congress, a candidate for Congress in Maryland fighting a hotly contested election had recently asserted that the colored race should be denied the right to vote because no one of the race had ever yet reached the dignity of an inventor. This trope was used to justify white supremacy and support, despite much evidence to the contrary, the assertions that African Americans could not invent as proof that's proof of black inferiority. She also pointed out the lofty symbolism of patents in this country, what it means to hold a patent, to be an inventor, and how it is a representation of American might and American exceptionalism and even citizenship. The results of it being excluded or having reduced access to these benefits can be profound. So when we talk about increasing the numbers of participants who are of, women or underrepresented minorities, this is not just diversity for diversity's sake. There are real national competitiveness issues driving this push, in addition to equity, inclusion, and social justice concerns. But there are also many benefits that can come from this approach. So the business case for inclusion and diversity, a 2015 McKinsey report on 366 public companies found that those in the top quartile for ethnic and racial diversity in management were 35% more likely to have financial returns above their industry mean, and those in the top quartile for gender diversity were 15% more likely to have returns above the industry mean. In a global analysis of 2,400 companies conducted by Credit Suisse, organizations with at least one female board member yielded higher return on equity and higher net income growth than those that did not have any women on the board. But does that matter for inventing? Yes, I think it does. And I'll give an example from the pharmaceutical space. When R&D decisions, what you're going to spend your money on, are based on a consumer's ability to pay, what innovations are produced? Well, according to the European Patent Office, it's what you might expect. R&D follows the money, not the disease. And so what you see there is the global disease burden versus the number of compounds in development, with vastly more compounds in development for cancers than for infectious diseases, even though there are many more disability-adjusted life years lost due to infectious diseases than cancers. but that is a result of targeting diseases that are more likely to affect wealthy individuals who will be able to pay for the treatments. Similarly, we may be underproducing certain inventions because those with an incentive to find solutions are not engaged in innovation. So we may be missing out on inventions that particular groups in society would otherwise invent. There is a long history of neglect of diseases that predominantly impact women. A study of patents from 1976 to 2010 found that patents with all female teams were more likely than all male teams to focus on women's health, and also more likely to identify differential side effects and treatments that work better for women. It has also been noted that not focusing on women in designing products has resulted in cell phones that are 55% too large and car designs that are 47% less safe on average for women. In that same study, male inventors were more likely to generate patents that address topics like erectile or prostate than menopause or cervix. Male inventors also tended to target diseases and conditions like Parkinson's and sleep apnea that disproportionately affect men. Not surprising. So the findings, the authors of the study note, highlight how demographic inequities in who gets to invent can lead to demographic inequities in who benefits from invention. Recent work also shows how increasing the number of Black physicians benefits Black patients, and more generally, the benefits of matching minority patients with minority physicians. So the world needs more inventors like Dr. Patricia Bath, a Black woman who invented a laser treatment for cataracts, which was inspired by her observation that Black Americans were twice as likely as white Americans to suffer from blindness due to cataracts. Now, of course, her invention is going to benefit everyone with cataracts. And to be clear, I'm not saying that women only invent for women and Blacks only invent for Blacks. In fact, one of the librarians helping me collect data for this project told me of a female inventor she knows who patented a prosthetic testicle, yes, for men who have had one removed for testicular cancer or some other reason. So women are just more likely to invent solutions to problems that uniquely affect women than are men. It was interesting to me that I saw a similar phenomenon on the continent of Africa when I was participating or lecturing in the Emory Advancing Healthcare Initiatives in Africa project, which teamed law students and MBA students from the United States with African researchers to work in a sort of boot camp to learn innovation commercialization fundamentals. And one of the things that struck me was that these African scientists were developing solutions to local and national problems. They were focusing on things like Rift Valley fever, okay, and immunotherapy for scorpion stings, because these were the problems that people in their communities and their countries were facing. So it's important to support researchers in low and middle income countries, yes, but it's also important to support inventors from underrepresented groups, including, for example, veterans. So all of this is to say it's about more than who wins the race to have the most patents. This is about who gets to benefit from technological developments, who gets to be seen as intelligent, even as American. All right, I am running out of time, so I'm going to speed it up. So what are some current efforts to increase the participation of underrepresented groups? This is a topic that is very important to me because I have interacted with the patent system in many different roles listed there. I am a co-inventor on 2 patents. I've been an R&D engineer, patent attorney, patent law professor, and in each of these roles, I am in the minority by a large degree. So I was really excited and thrilled when Colleen Chen, a professor at Santa Clara Law School who is doing path-breaking work with agencies, companies, and firms on piloting rigorous diversity initiatives, invited me to join her on this journey. And we organized a conference last fall at Santa Clara in conjunction with the U.S. Patent and Trademark Office on innovator diversity pilots, the first of its kind. And it was packed with so many creative ideas about how to incentivize innovation and to identify problems that are keeping, for example, women from patenting. They may be inventing, but often not patenting. So yes, to speed it up. So first, things that the PTO itself is doing. Coming out of the Success Act and the report, they created the Council for Inclusive Innovation, which has already launched a number of initiatives, including an innovation internship program for students at community colleges and universities, a first-time filer expedited examination pilot to help independent inventors get their patents faster because they might need them, because they're wanting to get out in the marketplace, expanding free legal services through the USPTO Law School Clinic Certification Program, which the clinics at law schools tend to support disadvantaged populations in obtaining patents and other IP rights. And a community outreach campaign. Many patent examiners now telework from across the United States. And so somebody had the great idea of, well, why don't we get those examiners in their communities, many times they're in rural communities, to go to schools and other places and talk to children, to students, about inventing, about patents. And then these are other PTO programs. There are a variety of law firm and corporate initiatives I want to just talk about real quickly. So the On-Ramp Fellowship, Karen Ulrich Stacy, she used a Moneyball data analytics approach to help women who had taken off 10, 20, even 30 years to raise families, but wanted to now come back into the practice of law. She identified factors that really indicated success, and it might not be the prestige of the law school from which the person graduated. And she then approached 4 firms, law firms, Cooley, Baker Botts, Sidley Austin, Hogan Lovells, and got them to offer fellowships for women at these firms, and it worked. She brought 200 women lawyers back. 20% of them were patent attorneys, 30% women of color. 87% of the women overall received and accepted offers. You might have heard about the Mansfield Rule, which is named after Arabella Mansfield, the first woman admitted to the practice of law in the US. The idea came from a Women in Law hackathon. And the idea originally was to interview 1 woman for every leadership role in every search. It's expanded to 30% of women and racial and ethnic minorities being considered for leadership positions, and many more. It's just really evolved, and it's evolved in a way to hold these firms accountable. They can get different kind of certifications. They have to share their numbers every year, so it's not like once you get it, you keep it. You have to keep showing that you're entitled to it. And they're actually starting to see some results. The Schwegman, Lundberg, and Wassner firm, this is Piers Blewett, they created a whole video series. You can go online, and it's for students, engineers, high schoolers, to give them content about inventing, as well as about being a lawyer, a paralegal, case management. I love some of these titles here. Being a responsible team mentor, learning from mistakes, that's a very good one. But it's important for people to learn how to do these things. Okay, I'm not going to talk about Howard. Yes, has been doing some great things. Michelson IP, creating all kinds of resources that anyone can access. The Harity firm, and this came from a real aha moment after a car accident, as I understand it, that one of the founders of the firm had. They have a wealth of diversity initiatives, including Patent Pathways, which is a program focusing on increasing the number of racially diverse women patent practitioners. And so they partner them with folks in law firms, they have corporate partners, individual mentors, and they're having a lot of success. Adapt Legal, so this is Jeremiah Chan, and these are all folks who spoke at our conference. Meta is doing some amazing things, and there are more than 60 companies that have taken a pledge to focus on increasing the diversity of the inventors within their companies and to find out why perhaps women are not inventing at the same rate as men within their companies. And sometimes it's as simple as men are more likely to complete an invention disclosure after hours and women aren't staying after because they're going home because they have to take care of kids or fix supper or whatever. And so they're not getting invention disclosures filed. All kinds of things. Women less likely to see themselves as an inventor, as entitled to that name. Having opt-out versus opt-in systems where someone is going around assuming that people have come up with an invention and just wanting to find out, okay, what it is. ADAPT, I need to mention this. This is wonderful. It's like a clearinghouse, a hub. There are so many programs, and if your law firm is doing stuff and it's not on ADAPT, you should get it on there because it's a great way for others to find out what you're doing and find out best practices. Yes, the patent pipeline program that ADAPT works on also focused on bringing folks to be patent practitioners from underrepresented groups. And yes, this is a hub. Whew, yes, I'm a minute over time. So I'm going to end with this. I love this quote, and this is one that Jeremiah shared from Arthur Ashe. Start where you are. Use what you have. Do what you can. I think it speaks to people individually, organizations collectively, and to the United States as a country. We can start from here and make a brand new end, expanding our innovation ecosystem diversity and enhancing our global competitiveness. There are myriad ways discrimination and bias can combine to profoundly limit inventor participation in the patent process, but the utilitarian purpose of patents, sorry, Kaylee, is to incentivize inventors to invent and disclose. So it makes sense to incentivize as many and as diverse a group as possible to maximize the likely output of innovative activity. This makes sense in terms of our geopolitical aspirations as a country, but hopefully also our democratic commitments to provide opportunities for flourishing and reaching one's potential that are available to all, not a select few. Thank you.
Thank you. The reference to time was because Professor Bagley is eager to engage with you and to answer questions from the floor, and we have until 5:30. So if anyone has a question, if he or she could please raise your hand, and I will call on you. And if we can't hear the question, I will repeat it, but I think a microphone is coming your way. So if I buy you 3 more seconds, we will be in good shape here. Thank you. Your question, please.
So the question is, you get a patent. What can you do with it? One of the things you touched upon is resources and companies that actually engage in active suppression and by litigation. To what extent is litigation acting as a suppressor to innovation in this area? And is that the problem? And I want, if that is, what can be done to balance the scales so that someone who, let's say, goes through one of these programs and gets that patent can do something with it? Because if they don't have the resources to fight for that patent, for licensing, for getting the benefit from that patent, there's no incentive.
Okay,
Yeah.
Thank you.
So that is definitely one of the problems. And Professor Murray should really come up and talk about the small claims
That's
project.
a rhetorical statement.
But it is a problem that hits very close to home for me. Because as I said, I'm a co-inventor on 2 patents. The second patent, my husband and I just got in August of last year. It's on a new bedding technology. And you know, they say necessity is the mother of invention. So my husband says that I pull the covers off him at night. I don't know what he's talking about, because the covers always end up on his side of the bed. Nevertheless, he had this wonderful idea and kept wanting me to patent it, and I finally gave in. I'm like, okay, let's see if we can get a patent on it. But it's basically an invention where the top sheet has flaps, personal flaps. So I have my flap that I can wrap around me. No air can come down my neck when he's pulling, and he doesn't need to pull because he has his flap. But at the same time, we're still connected at the bottom part. So yeah, and we're in the process, he's in the process of full-time working to get it on the market. And we are concerned about the possibility of infringement and not having the resources to enforce, our patent, or trying to find, someone to invest in the litigation. So it's absolutely a concern for small inventors, and I can relate to that. And hopefully, yes, we need a multi-pronged approach to the various issues that make it difficult. I mean, because for the longest time, I didn't even want to bother the patent, because one, it's expensive to obtain a patent, and I know more about the patent system than most inventors. And I had a wonderful, amazing student, former student from 20 years ago, who wrote a wonderful patent application, because I'm like, I haven't done this in a minute. I'm not writing this patent application. But everybody doesn't have that. And that's why the clinics are important, hopefully having a small clinic. We need more tools to address the various challenges that make the patent system out of reach for so many people.
Thank you. Other questions? Yes, and does anyone else have a question, just so I know where I will go next? I'm sure there will be one. Please. That was my buying time.
Fernand Baptiste, Marquette Law School student. My question is, do you think that overall reducing the USPTO fees for small and micro entities is a step forward, or overall, on a larger scale, it's significant?
So that's an interesting question. My answer is yes and no. And why do I say yes and no? The fact that we have small entity fees is important. Small entity fees, if you have an organization that has fewer than 500 employees or university, et cetera, then you get reduced fees or cut like by half. And micro entity fees, if you've ever received fewer than, I think, 4 patents, and you have an income below a certain level, then you get even further reduced fees. I think it's like a 75% reduction. That's nice. And why that is nice is if you look in comparison at countries and regions that don't have that, you have even less patenting by small entities. Like Europe, it's like 90% of patents are by large entities because they don't have reduced entity filing fees. However, the biggest cost in obtaining a patent are not the filing fees, it's the patent attorney who's drafting it, they're responding to the office actions. I mean, when I was in practice, and this was a pharmaceutical case, but we spent over $100,000 responding to an office action. Now, it paid off because the client was able to sell that patent application for $20 million later, but nevertheless, it can take a lot of money. So, yeah.
Thank you. Other questions? We certainly have time. Well, let's see if there are other questions. Whom are you pointing to, Kaylee?
Bruce had his hand up. Oh, okay. Oh, not Nies. Okay.
Do you have a question?
Yes.
And then we'll go to the back row for the follow-up.
There's the post patent issued expenses, such as for litigation, but there's also the expenses for an infringibility study, a thorough exam of prior art, and things like that.
Absolutely.
And also, if you could comment on Barry Lynn's book, Into the Line, about forced licensing after World War II.
I haven't read it. I'm sorry. I can't. But you're right. There are costs all along the way. And yes, if you're a small entity, you're probably not going to be paying for a freedom to operate opinion. You might need one, but you might just take your chances. But yes, all of those cost.
Please. And then we will get Professor Boyden's question after that.
My brief follow-up is, would the ability to recover litigation fees bring back into balance the incentive for someone follow up and pursue a patent against a company with greater resources?
Yes, I have often been favorably inclined toward loser pays regimes as a way to make it more possible for small entities to enforce their patents. Some other countries have that. We don't. And yeah, I think that could be quite helpful.
So we will have our last two questions, one from Professor Boyden and the other, because I have to, live with these people every day, from Professor Murray, who I know has things that she wants to say. Please.
If I could just make one more point.
Sure.
The challenge with relying on loser pays is that because of the jurisprudence of the wonderful Federal Circuit, it's hard to know for sure whether you're going to win, and so it's not always clear cut that when you're making this decision that, we've got a slam dunk case. So, yeah.
Please.
So in terms of the efforts to broaden the class or the group of people applying for patents, you listed a number of potential or solutions or efforts being undertaken for that at the end of your talk. One of which I think was government supported, but a lot of them were private.
Yeah.
Is that enough, the efforts that are being undertaken, or is that just a drop in the ocean? And if it's more the latter, what else needs to be done?
Great question. So I don't think we know enough to know yet. I would not want to say it's enough. No. And a lot of it is ad hoc, and unless there's some accountability, folks can start, but they may stop and not continue. That's what I like about the accountability that's built into the Mansfield Rule program. And people are trying different things, and there was a big push. A lot of these things came at the same time. Also, the murder of George Floyd. So that's why the Schwegman firm, their headquarters is in Minneapolis, and they're like, we need to do something. Lots of firms did, but the outrage can die over time, and do you have the same commitment? So unless we have real commitments, real accountability, and I really think we need a framework. And we're going to have to, Colleen's work, Colleen Chen, who I mentioned, is wonderful because she very much focuses on rigorous innovator diversity pilots. What are things that we can try and see if they work? So let's try something, let's give this a try, see if it works. If it doesn't, okay, what do we learn from that? Let's move to the next thing and try that. So it's gonna take time to collect data from various pilots that are ongoing now to try to figure out, all right, what are the best tools that we can employ here. And a lot of it comes down to education. And can we start earlier, encouraging girls to not think that they're bad at math and not veer away from science, and Black and brown children as well, letting everyone know you can do this. So there are lots of things that we can do, and we're definitely not doing everything that we could.
So let me say three things in conclusion here. First, we will have a reception in the Zilber Forum, and I hope that as many of you as wish, and in fact, I hope all of you will stay and have something to drink or to press another question on Professor Bagley. That will be wonderful. Second, I want to thank all of you for coming here on an uncertain afternoon, not uncertain in terms of whether we would have a wonderful lecture, but as I arrived with Margot's mother from the hotel, after picking her up, we were greeted by an attorney who was walking out as we were walking in, and she introduced herself to me and said, "I'm going home because of the weather." So kudos to all of you for not going home because of the weather, and it still seems to be good out there. Third, and truly most importantly, a very warm thank you to Margot Bagley for a really, really fine Nies lecture.